Hello, my name is Don Blythe. I'm a CPA and a divorce financial analyst. I'm also a financial mediator in San Francisco. With me today is Lissa Rapoport. Lissa is a family law attorney and managing partner of Leland Paracini in San Francisco and Marin. And today we're going to talk about California's attitude towards spousal support. Welcome, Lissa.
Thank you, Don.
Tell me, what is spousal support and why is spousal support?
So spousal support is intended for two different reasons. So the first reason is when couples first separate, the intention is to help the parties maintain the status quo. So to ensure that money is available to both parties so that all of their respective bills can get paid, the mortgage gets paid, school tuition gets paid, so on and so forth. It's to maintain their status quo pending a final judgment and division of assets and all of those things. In the longer phase, when you get to the judgment aspect of spousal support, the court is going to look at different factors to determine if a longer term award of spousal support is appropriate. We'll talk a little bit about that later.
What are some of the factors that a judge might look at in determining the amount and duration of support?
So in the longer term, the court is going to look at Family Code 4320, and there are many factors that the court looks at when making a determination as to longer term spousal support. And those include things like how old the parties are they in good health, have they been out of the workforce for a period of time raising children, what is their earning capacity if they're not working, how long have they been married, I think I might have mentioned that, and the marital standard of living are sort of the primaries, and need and ability to pay. So what is the need on the one side and what is the ability to pay on the other side?
Is behavior considered a factor too? If there's been spousal abuse or there's been other kinds of negative behavior, does the judge consider those things?
So generally, the state of California is a no-fault state. So generally, bad behavior is not considered. However, if there is domestic violence, that can be a factor in how the court looks at spousal support as to either the person asking for it and the person who is being asked to pay it. They will look at domestic violence as a factor.
How much discretion does a judge have in deciding the amount and duration, since there are so many factors?
The court, in my experience, has a lot of discretion to weigh and analyze the different factors in Family Code 4320 based upon the evidence that's being presented to the court. They do have to, however, follow the statutes, and they do have to look at those factors when making that determination.
Does that mean two judges would basically come to the same conclusion as to amount and duration, or would there be possible flexibility in that?
I would say that a fair response to that would be that judges might come up with different outcomes. They might come up with different answers to what is appropriate spousal support. I don't think they would be wildly different, but I do think that as human beings, people are going to look at certain facts and circumstances and see them through their own lens. So you might get a different order from a different judge.
Is that maybe one of the reasons that spousal support is one of the more contentious issues in divorce?
I think that spousal support is a contentious issue because it is an emotional issue for people. It is often fraught with a lot of fear and a lot of anger and frustration and emotions around someone really feeling that they need spousal support, and they're fearful because they don't have income. Maybe they haven't worked for many years, things such as that. The payor spouse may feel resentful that the other spouse isn't working and feel they could be working and therefore they shouldn't have to pay spousal support. And at the bottom of all of that is really a scarcity mentality that comes from the fact that most families, when they separate, don't have enough income to live the way they were living when they lived together. So that scarcity concept creates a lot of anxiety and fear.
Can you talk a little bit about temporary versus long-term? How is each calculated, the duration of each, the purpose of each?
Sure. So temporary spousal support is when people first separate, they will often, either in mediation or collaborative or in litigation or negotiated settlements, they will come up with an interim number to maintain that status quo. And often people will, in a litigated sense, look at the Dizomaster, which is a computer program like a calculator. They will input the income, they will input tax deductible items, and the program spits out a number. And it is a interim spousal support number that often is used to determine what appropriate temporary interim spousal support should be. Sometimes in a consensual dispute resolution process or in a non-litigated process, couples can look at their need and a needs-based determination as to what's needed in respect to spousal support. So what does a couple actually need each month to meet their bills, to meet their basic expenses? That's another way to approach it.
How about marital standard of living? What impact does that have, especially in a town like San Francisco, where it's expensive to live, and it's more expensive to live in 2 houses than 1? How does that play out?
Marital standard of living is a very fictional concept in some senses, because, as you say, it often can't be met when people separate and you're living in a very expensive area like San Francisco. Marital standard of living is a factor, and it is something that the courts look at. It's something that each party is going to look at in regard to how much did we spend every month, what are our basic needs, what is going out, what is coming in. It's a factor, but it's not the only factor. And unfortunately, most parties cannot live at the marital standard of living, but it is a factor, and it does give people good information. Unfortunately, most people can't attain that once they separate because the resources are simply not adequate.
What happens if a spouse cannot or won't work, both during the process and afterwards? What's that look like?
So often there will be a spouse who has been at home, raising children, running the home, so on and so forth. That spouse is going to need time and a plan to get back to work, and the court is going to expect that person to return to work. But the court's also going to be thoughtful that that person's not just going to run out and get a great job and start a new career after having been out of the workforce for 10, 15 years. So often a spouse can work with a vocational counselor. They can come up with a plan to re-enter the workforce, and that may mean they're going to go back to school. That may mean they're going to get computer training. That may mean they're going to need certifications of some sort, and they're going to come up with a plan to help that person get back into the workforce. That's one scenario. The other scenario is the person who doesn't want to go back to work, and they're resisting. They've been at home doing what they've been doing for a long time, and that's how they see themselves. That's their role, and they become very attached to being that primary caretaker, raising the children, so on and so forth, and they're scared and they don't necessarily want to go back to work. And the court, under those circumstances, can do similarly. They can have that person work with a vocational counselor. They can make a seek work order, which is something to the effect of you need to make best faith efforts to apply for X amount of jobs a week and submit resumes, so on and so forth. And at the end of the day, if that person resists all of that and will not return to the workforce, the court has the opportunity to impute an earning capacity to them. That can be determined by a vocational counselor who says, if this person went right now and applied for various jobs, they could work as X, Y, or Z, and they could earn this amount of income, and the court can input that into the support calculations to determine appropriate support based on an imputed income. If it's the payor spouse who quits a job, same idea, that the court's going to require that person to get back to work, and if they don't, the court can impute an income to that person as well. So when there aren't enough resources, people have to understand that they each have an obligation to contribute to their own support after separation.
Does that also apply to a spouse that is underemployed but still working?
Yes, the court can, same idea, impute an income if that person doesn't want to work full time. They can say, if you worked full time, you would make X, and that's what we're going to input in factoring spousal support.
Who pays spousal support, the husband or the wife ordinarily, or does that matter?
It doesn't matter. It's who is the higher resourced spouse. So in many families, the woman is the breadwinner. In other families, the husband is the breadwinner. So whoever is the higher resourced spouse is going to pay the spousal support. There's no gender bias there.
No bias there.
No.
Not like there used to be.
Mm-hmm. Yeah.
Talk to me about cohabitation, remarriage, and death. How does that impact spousal support?
So if a supported spouse begins a new relationship and begins to cohabit, the court can modify spousal support based on a rebuttable presumption of decreased need. The idea being that if you move in with somebody, that person is going to contribute to your overhead, and therefore you would need less spousal support because that person might be carrying half of the overhead in your home. Now, that's not always the case. That's why it's a rebuttable presumption. And you have to prove that. So that is a matter of going in and showing that someone is actually contributing to the overhead and reducing that person's need. If someone passes away, spousal support will end. If many families will put life insurance in place to ensure that if something happens to the payor spouse, that the recipient spouse is protected as best they can through life insurance. And then you asked one other. Remarriage, thank you. So remarriage generally will end spousal support if the recipient spouse remarries. That is a termination of spousal support. If the payor spouse remarries, there is no termination of spousal support.
Talk to me about modifiability. Sometimes I understand couples can agree to modify spousal support under certain circumstances after divorce. Other times they choose not to. What might be the reason for that?
So sometimes people will negotiate a spousal support order that is non-modifiable because they want certainty. They want to know that this is what I have to pay every month. This is what I'm going to receive every month. This is the duration. And under no circumstances is it going to be modifiable. That's for certainty. Other families will navigate that in a different way, and they will say that it's non-modifiable unless, and they'll build in carve-outs. So they'll build in, if someone becomes disabled, that's paying spousal support. If someone gets laid off and loses their job, if someone suffers a decrease in income, their pay gets cut by 30%. Those sorts of circumstances can be built in as being modifiable, so that if they happen, both parties understand that they have to go back in and reevaluate spousal support and adjust it appropriately.
If a judge were to decide that issue, how would that judge typically decide it, modifiable or non-modifiable?
My experience is that in a courtroom setting, spousal support would be modifiable under changed circumstance. And so any change of circumstance on either side would allow either party to come back in and seek to modify spousal support.
Good. Taxability. I understand there's been some tax law changes at the federal level.
Correct. So on a federal level, it used to be that you could deduct spousal support as the payor. It was an above the line deduction, and you would pay taxes on it as the recipient. Now on a federal level, you can no longer do either, which is, in my humble opinion, very unfortunate because it creates much less net spendable income for families who are already trying to maintain two homes on income that used to maintain one. So it creates a real hardship for families.
But the state of California still deals with the old rules, right?
Correct. And you do for example, the DISO master will factor that tax deductibility on the state level for you. So it gives that as a factor. Not much of a difference though.
Okay. Talk to me about do-it-yourself divorces and mediation and collaboration. How how does spousal support differ generally in those kinds of approaches versus if you ask a judge to decide?
Well, in the mediation and in the collaborative processes, my experience is couples will often look at a needs-based spousal support in the sense that they will actually look at their inflow, what income they have, what expenses they have, and they will try to come up with a needs-based spousal support number that really reflects their standard of living to the best that it can. The Dizo Master is rather artificial in that it doesn't factor your expenses in. It's just what's the income and what does the California guideline decide is appropriate temporary spousal support. So a needs-based assessment is often more reasonable, more realistic, and it gives people a greater sense of control over how they're going to divide the income so that they can both maintain a standard of living, probably lower than what they're used to, but a little more realistic.
Thank you, Lisa. Any parting words for our viewers?
I can't think of any off the top of my head, but it was a pleasure talking to you.
Thank you, everybody.